Once again, it's a distinct pleasure to moderate a panel here, this time on the nexus between international and transnational and organized crimes. Just a word on what the Wayamo Foundation has been working on this issue for quite a long time. We've brought together various different types of actors who work on transnational and organized crime around the continent, particularly in Kenya. We recently had late last year, had a conference in Botswana on the subject. And I think the core issue, and hopefully something that will really get out of this panel, and I hope we get out of this panel, is that we often talk about these issues in silos, but we really need to focus on the linkages, this nexus between transnational and organized crime. I do have to admit, I have a little bit of self-interest in moderating this panel. I'm working on an academic article on the subject, which I've provisionally titled, "This Mass Atrocity Has Been Brought to You by the Ivory Trade," linking these crimes and showing how the ivory trade has actually fueled the commission of war crimes in East Africa. I'm extremely excited, and I think we have a fantastic and diverse panel to talk to these issues of linking transnational and organized crimes with international crimes. So to just very briefly introduce our speakers, we have Philip Ambach, who is the Special Assistant to the President of the International Criminal Court. We have Charles Goradema at the Center of Criminology here at the University of Cape Town. To my left, we have Jemima and Jerry Kariri, the Senior Researcher at the Transnational Threats and International Crime Division Institute for Security Studies in Pretoria. And finally, but certainly not least, Pierre Saint-Hilaire, Director for Counterterrorism at Interpol. So this will be more of a conventional approach to moderating. Each of the speakers will speak for 10 minutes, and then we'll open it up for some questions, both from myself as well as from the audience. So with that, Philip, please.
Thank you very much, and good morning to everybody. I wanted to start with some remarks that maybe also set the scene a little bit in the legal and the conceptual context, and that is, how do international core crimes or core international crimes relate to transnational crimes? What are the overlaps? What are the distinct features? So in terms of defining the relation, first one would have to look at what is actually and core international crime, so the definition of terms in this regard. And to start right ahead with this, core international crimes are international, as one says, for two distinct reasons. Number one, that's a little bit the tradition or the traditional look at it. They have come to existence as being sort of the worst violations that we've seen in wars between states. So it was really the armed conflict-related crimes between states, the mass criminality that has been brought upon by violence and war. The second distinct feature is that these crimes, international crimes, are defined in international conventions invoking individual criminal responsibility in order to protect genuine values of the world community. And these values are pretty much twofold. On the one hand, international peace and security. That is what you see in Chapter 7 of the UN Charter, for instance, as well. And obviously then the individual values, human rights, as we've discussed them this morning. And these you find in particular in the provision on crimes against humanity. Now, other big conventions that you may want to look at for the core international crimes are the Geneva Conventions, the Genocide Convention, the statutes of the Nuremberg Tribunal, and the statutes of the international tribunals, and finally, the ICC. Specific to the Rome Statute, you will find in the preambula a passage which says that the ICC covers crimes that are the most serious crimes of concern to the international community as a whole. So you see that this is again the sort of the linking factor. What are the main practical effects of this? Again, two. Number one, international core crimes override national sovereignty in that they trump dissenting or contrary national laws or national laws that do not cover the full criminality as we know them in the international scene. And it is the duty of every state to either prosecute these crimes or help others to do so. And this is again a passage that we find in particular in the Geneva Conventions and other treaties. How do transnational crimes stand against this? Transnational crimes are crimes that have an effect over national borders. They are crimes under national law in the first place. So the adjudicative jurisdiction is purely national. The common efforts of states when it comes to the prosecution or investigation of those transnational crimes is the common realization of congruent domestic interests of criminal prosecution. These crimes are predominantly committed by private persons or organizations. State intervention is not as prominent as you would have it, for instance, in the traditional setting of core international crimes. The specific item that we're looking at today is the transnational organized crime, which is the transnational crimes committed by a network or a group profiting from the sale of illegal goods or any criminal activity, rendering monetary profits wherever there's a demand. Examples here include what you have already seen and heard repeatedly: drug trafficking, human trafficking, smuggling of migrants, trafficking of natural resources, wildlife, illicit arms trade, cybercrime as well, and transnational terrorism, a crime that I want to also draw on in a minute. Again, important here, transnational crimes are perpetrated in particular for monetary gain. They do not target human beings, whereas in particular the traditional core international crimes do target persons, natural persons. How do these crime complexes stand to each other? How do transnational and core international crimes stand to each other? We see that we have a number of elements of transnational crime in our core international crimes as we have them today. To give you an example, human trafficking, deportation and forcible transfer, or sexual slavery, these three you can find as the sub-crimes in the crimes of humanity provision of the ICC statute, and the jurisprudence of the ICTY and ICTR have also dealt with this. So that means, in other words, you have these elements already in our international crimes, but in order to prove a crime against humanity, you always need to prove that there is a widespread and systematic attack against the civilian population as a corollary to that international crime. And that is obviously something that in many transnational organized crime settings you will have difficulty to prove, because this is something that you would most probably rather find in a failed state scenario, but not necessarily in a scenario where there's just organized crime happening in a functioning state scenario. Likewise, severe damage to the environment, also termed as ecocide. Again, something that you can find in the war crimes provision under the Rome Statute and also derived from the Geneva Conventions. Problem here, again, you will have to first prove that there is an armed conflict in order to get to the crime of ecocide. Your armed conflict is not necessarily something you will find in, again, a setting of regular transnational organized crime. Wildlife crimes, which could be arguably falling into these general war crimes provisions, again, the same problem. You will have the additional burden to prove that there is an armed conflict. Terrorism. We have a crime in international humanitarian law which is akin to that crime, which is the crime of terror. That is something that has been repeatedly brought forward by the jurisprudence of the Appeals Chamber of the ICTY. So you have a certain similarity between your transnational crime of terrorism and a crime of terror as defined in international humanitarian law. Problem, again, you need the armed conflict. Some transnational crimes, however, may have characteristics that may make them even freestanding international core crimes. And this is something that was discussed even at the Rome Conference in in 1998, a couple of crimes were discussed whether they should be inserted into the Rome Statute alongside the 4 core crimes as you find them: genocide, war crimes, crimes against humanity, and aggression. And this was, for instance, drug crimes, international terrorism, mercenarism, and willful and severe damage to the environment. This was, however, finally then rejected by the majority because, as it was generally said, there was no necessarily no proof of international customary or treaty law for these crimes to have made it up to an international crime, a freestanding international crime. It was doubtful whether crimes like mercenarism would necessarily make it up to the gravity threshold of a core international crime. And finally, again, the argument, well, these transnational crimes are usually encompassed in our core international crimes, so that this was finally dropped. One word on terrorism. I think that in terrorism we have a very interesting crime, which is not part of the Rome Statute, but argued by many it should. We do have a problem, however, that we do at present not have general international agreement as to the definition of the crime as such. And that is, again, the major hindrance for the discussion to move forward on whether that crime would at some point cross the threshold from a transnational crime, i.e. in national jurisdictions, to an international crime where there's a general agreement that these crimes are to be punished by the entire community. One word on the potential links we have. Why is this important? Because prosecutions and investigations at the ICC or at the international crime level will always and inevitably come across huge complexes of transnational crime. So these crimes are linked in a way. One crime fuels the other. And this is why we have to, on the one hand, differentiate between the two, but on the other hand, also look as to how we can connect the two in a network that brings us to dealing with these crimes. The benefit of codifying transnational crimes in international or regional conventions is therefore the fact that you can, on the one hand, solidify certain emerging core international crimes. For instance, the fact that you are not yet in a position to have a definition on terrorism, move on the discussion there, try to get international consensus, and then see to what extent you can codify this in a convention that is then being ratified by many or all states. But the same also goes for other transnational crimes that will remain within the national criminal law context for their focus as a property offense, because what you currently have is the problem that despite us having UNTOC, the UN Convention on Transnational Organized Crime, that convention is very much focused on a cooperation regime between states, but not so much on a definition of transnational crimes. Now, in order for states to cooperate properly and in order to have a coherent system of mutual legal assistance, what you need is them to agree on the definition of the crime and the modes of liability. One last word on the added benefit of making them a Rome Statute crime, because we hear this very often. Why don't we add it as a Rome Statute crime? Be aware of the incredibly difficult amendment procedure of the Rome Statute. This is one big topic that is often forgotten. Article 121 has a very arduous procedure for this. You need a 2/3 majority of all states parties in order to add a crime, and that in the current political context, I think, is something that will be extremely difficult to achieve. Therefore, I don't think that this option, while conceptually interesting, is necessarily something that is practically very conclusive. And in terms of tangible solutions, I'm not going to say anything because I suspect him asking nasty questions later. Thank you very much.
Charles, please.
I want to thank the organizers for inviting me. This is my very first opportunity to engage with the Africa Group and with the Wayamo Foundation. But I don't have much time, and sitting between Mark and Philip just gave Mark a further opportunity to terrorize me further and remind me that I don't have much time. Now, I really don't claim any knowledge or expertise in international criminal jurisdiction. But having spent the last 20 or so years in Cape Town gave me an excellent opportunity to become very familiar with transnational organized crime. For all its beauty, Cape Town does present you with a lot of opportunities to observe organized crime at work and in real life, because it's all around you. You don't have to go looking for it. It smacks you in the face every morning, whether it's from the pages of a newspaper or it's from just experiencing ordinary life. But transnational organized crime, of course, presents additional dimensions, additional challenges to just organized crime. But there are a number of observations that one can make on the basis of one's experience, and I've spent a lot of time doing a little bit of research with the assistance, I must say, the very generous assistance of sub-units of Interpol, Southern Africa, Interpol, East Africa. I don't know much about organized crime in West Africa. I've only read about it. But it seems to me the nub of the issue, the nub really remains information. Understanding the real issues involved in preventing, managing, and curbing transnational crime really turns on how much information, or the access that we have to information on the nature of the most serious forms of organized crime that are happening, information on who is involved, in what way, who are they connected to, how big are the crime networks that are at the center. And for all the experience that is accumulated and all the cases that have been prosecuted, our greatest weakness as societies, as the African continent, and as the world as a whole, I think, lies in the fact that the information that we have remains incomplete, pathetically incomplete, and quite inadequate when measured against the scale of the challenge that we have to confront. In some cases, the information is there, but no consensus has actually been developed as to what then to do with the information. While the processing, production, and sharing of information has greatly improved, there are still these gaps. At the same time, for criminals, the improvements in the production and dissemination of information has in fact been a huge advantage, and it has been at the center of the fairly rapid, phenomenal evolution of organized crime as it moved from what used to be the historical centers of activity, drug trafficking, human trafficking, trafficking of commodities, to other new forms of organized crime, which did not require the physical presence of the criminals in the places in which they intended to operate. Cybercrime, I think, is one prominent example, which Mark has already adverted to. Global criminal law has developed, with a measure of consensus having been established, both in terms of the content of some of the more harmful forms of transnational crime, as well as the procedures by which to tackle them. You may refer to examples like the various drug conventions, the UN Transnational Organized Convention, the protocols on human trafficking, illegal migration, the various regional conventions, and just as important, the soft law stipulations in the recommendations of the Financial Action Task Force, the UN Convention Against Corruption, and the various regional institutions established at the behest of the Financial Action Task Force, all going by various acronyms of different names: Manival, Esamlag, Giaba, Menafatif, and so on. But finding and using the information that is available still remains a challenge. If I may highlight some of the pertinent challenges that really emerge from looking at crime networks without looking at the mechanisms to combat them. One thing that is quite clear is that over the years, crime networks have demonstrated their capacity to adapt to their environment. As political and socio-economic changes happen, crime networks quickly learn and they adapt and they change their modus operandi. Political changes in particular present great opportunities for crime networks to change, because it is always of strategic importance to crime networks to align themselves to the political elites and the economic elites at any given point in time. And this they have done regardless of whatever region you are talking about. In the case of Africa, what increases the vulnerability is the cost of participation in politics. It tends to be, I think, disproportionately more expensive to participate in politics in Africa than it is in other parts of the world. And because of that, emerging politicians who almost invariably do not have the resources that they need in order to run successful campaigns virtually have very little option but to land in the lap or in the arms of organized crime networks who are more than willing to fund their activities with the promise, of course, that once political office has been won, then much else will follow. Like what the great Kwame Nkrumah is credited to have said, you need political power first and all else will fall into your lap. Criminals took that seriously to heart. Research has shown that economically motivated crime in South Africa is committed by individuals who comprise networks, and that there is a definite link between the shadow and the mainstream economies. It has also demonstrated the existence of regular interactions with some public officials. There are examples almost wherever you look. I think here we only need to talk about the late Commissioner of the South Africa Police Service, Mr. Jackie Celebi, who was convicted of corruption. Public officials give a cutting edge to economic crime and also a measure of protection. At the level of policymakers, relationships are connected to the cost of politics, as I have said. Now, there's a link between transnational organized crime and the fragility of states, in that the proceeds of transnational crime are quite often used to undermine the integrity of public institutions, whether you're talking about the police or you're talking about the financial regulators or indeed any other public institutions that are mandated to monitor the activities of crime networks. And to the extent that they compromise the integrity of these institutions at a time when they are trying to establish their credibility in the eyes of the public, they just make it that much more difficult for emerging institutions to establish legitimacy, to establish any degree of public trust. It then means that the prospects of generating even domestic investment are that much less. The prospects of building and mobilizing public trust is also that much less. In the case of Cape Town, one of the observations that we made a few years ago was that it was, in fact, it had led, because this happened a long time ago, it's probably just continuing to develop, it had led to the development of what one could say parallel systems of governance, where victims of crime would not entrust their confidence in the police or the public authorities, but would rather do that or entrust it to other forms of authority like criminal gangs, crime bosses, and so on, with the result that you had this parallel system of governance which continued to fester and to develop. As far as combating organized crime, it then means you cannot even begin to use the public in order to fight organized crime, because they are pretty much clients, vassals, and tools that can be used by organized criminals. Organized crime has been found to be a major contributor to illicit financial flows from Africa at a continental level. I think the Mbeki high-level panel on illicit financial flows from Africa, which reported last year to the AU, made that finding. The actual percentage of contribution was in the region of 30%, which is still big when you take into account the volume of illicit financial flows stemming from Africa. And the reason why they've been able to do that is organized crime networks have moved into the area of corporate criminality, or the abuse of corporate institutions, in order to perpetuate organized crime, which has further blurred the distinction between what used to be known as sort of the blue-collar organized crime and the white-collar commercial crime. In the area of natural resources, smuggling of minerals, precious minerals, smuggling of wildlife products. Here you find corporate criminality playing a very big role and contributing very significantly to illicit financial flows. I will be able to make some further points during question time. Thank you.
Thank you very much. Please.
Thank you very much, Mark. And I would like to thank Wayamo once again for convening this very timely symposium. It becomes very difficult to give a presentation after experts such as Philip and Charles have spoken. But I think what's most important is that, and what's exciting for me is that it actually leaves me with very little to say, and importantly, so just to make conclusions. Now, I will speak to transnational crimes in Africa becoming a remit of international crimes across Africa, and the advent of globalization has presented in various developments, and some of these developments obviously have created borderless crimes, created space for developments, communication, economies have advanced, but with this positive development has also come the challenge of transnational crimes, whereby various criminals have used that platform to conduct their fraudulent activities. Now, transnational crimes, as we have heard from Charles, are many. In fact, some reports indicate that there are more than 54, and they're becoming more dynamic, very elusive, and in particular creating a lot of challenges for the criminal justice system. And they have generated untraditional or untraditionally connected connection between different crimes. Basically what I'm saying is that crimes that were previously not connected, are now connected. For example, if you look at what Philip has alluded to, when one thinks of transnational crimes, in some instances, they get connected with terror groups. And obviously what this has done is that it has created some really dire consequences in terms of responding to them and in terms of the serious outcomes. Now, additionally, transnational crimes, which we have heard about, have really flourished in Africa. I think we've discussed this since yesterday. And obviously there are challenges, a cloud hanging over Africa because these crimes continue and not much seems to be done about them. And obviously what one needs to think about is what is the interconnectedness between transnational and international crimes, and what are transnational crimes doing to fuel or to feed into international crimes. Now, there isn't a huge body of research, and knowledge about this, but going by the trends, international crimes seem to benefit from proceeds of transnational crimes. And for one to understand this, it's important not to isolate atrocity crimes perpetrators and organized crime networks in silos, but to seek to examine the interactions between the various crimes. So let us not separate them. Let's try and figure out how these crimes work and how we can deal with them not separately. Because basically what happens is that in some instances, the criminals that perpetrate these crimes were either previous criminals of the alternative crimes, and in some instances, they actually have, they belong to the same sort of groupings, and also have international or regional linkages. But obviously, it might be irresponsible to arbitrarily conclude that these crimes are directly connected. But I think what's most important is to recognize there might be a causal relationship. And by going with various trends, I think there is actually a correlation between the two, whereby, in my opinion, transnational crimes create a fertile ground for international crimes. It may not be direct, but what is important to notice is that in some instances, one needs to think about the motives as well as the operations and the outcomes of the two crimes, particularly transnational crimes feeding into terrorism, into terrorists, into international crimes. Perhaps just to elaborate, and this is just to build up on the discussions that we have had from Philip and also from Charles. If one thinks about terrorism as a transnational crime, that is international terrorism, and in some instances even domestic terrorism, you find that money laundering as a crime fuels terrorism through terrorism financing. And there are so many other small and huge other related crimes, including trafficking in illegal arms and weapons, drugs trafficking, abductions, and ransoms. As we had yesterday, we've got from the judge Billy yesterday talked about the weapons that are illegally transported to Syria, and obviously we know what the outcome of those weapons are. So we find that the proceeds that terrorists use to finance their work eventually obviously support the terror attacks or terror actions, and like the connection we've had with Boko Haram and in other places whereby international crimes have been alluded to have been committed out of the action of terrorism. On the other hand, like Mark mentioned earlier, environmental crimes have also really fueled or supported international crimes, particularly in the East African or Central African region as well as West Africa. The Central African Republic as well as the DRC, and also the crimes that were committed by Joseph Kony in Uganda and across the borders were also funded from proceeds from the sale of elephant tusks. Even in Somalia, those that have worked in Somalia, Al-Shabaab has also benefited from proceeds of elephant tusks as well. In other instances, you find that the sale of timber has really been used as a resource to generate funds to either buy illegal arms or to either make sure that the various crimes that are intended to be perpetrated are successful. And it is very sad that even in a country like Democratic Republic of Congo, a very resourceful country, a very rich country, illegal mining, is actually used to fuel, crimes, international crimes. And it's unbelievable that we can actually have a country being in war like forever. I mean, as long as I remember as a little girl, I know that Congo has always been, in war, that women are running up and down with children. So some of these resources are actually used because, of the sort of organized system of the crimes. The proceeds are used to eventually perpetrate these crimes. And I can go on and on with examples, even in Angola, the war economy of Angola, as well as Sierra Leone. I think you all are aware of what happened in Sierra Leone with the Charles Taylor. Corruption has been widely discussed today, and I think I don't have to elaborate on that. Charles also talked about corruption, whereby corruption has got different wings and it comes in different phases. So if you think of corruption in terms of siphoning funds to fund a certain group that supports a political leader, if you think of terrorism, of corruption that eventually contributes to resourcefulness of a particular group. Terrorism, corruption is a big problem. Human trafficking has also been discussed, and I'm not going to take much discussion on that. And obviously, poor border controls in Africa, that also has to do with, either management of the borders or corrupt officials that sometimes provide illegal travel documents, has also been used, to raise funds, and eventually we find that it sort of contributes to international crimes. Just to give a conclusion, and not forgetting cybercrime, because there's a lot of money that is being transferred and siphoned through cybercrime to fund various processes that eventually may translate or contribute to international crimes, is to say that transnational crime is actually becoming a remit for international crimes. However, much more research needs to be undertaken in order to inform the responses and to inform this development. At the same time, it's important to ensure that our criminal justice systems is well equipped with skills and resources to be able to respond to these crimes. But what is most important as well is that I think we need to engage into some sort of a study to find out what are the root causes of these crimes. And once we are able to deal with the root causes, my opinion is that we might be able to respond to the crimes. And obviously, coordination at the national level and at the international level is very important. And obviously, considering the transnational nature, especially of transnational crimes, it's important that we engage in international cooperation in criminal matters in order to be able to respond to these crimes. Thank you very much.
Here, please.
Thank you very much. As the last man standing, I think I probably have even less to say. So to make an impact, I think I'll look at international cooperation and put everyone in a very mournful disposition. Because when I'm looking at the state of how countries deal with all of the international crimes that our colleagues have pointed out, all of the transnational crimes, things are not looking very good, certainly from my vantage point. A little bit on the transnational nature of crime. The international community recognized that transnational criminal enterprises were able to shrink the world. And a response to that was the adoption of the Transnational Organized Crime Convention that you heard mentioned here. And you've heard as well mention of transnational. What does that actually mean? Well, there's a definition of it built into the convention that about 186 member countries have signed to. And it is, if it's committed in more than one state, if it's committed in one state but a substantial part of its preparation, planning, direction, or control takes place in another state, if it's committed in one state but involves an organized criminal group that engages in criminal activities in more than one state, or the catch-all, if it is committed in one state but has substantial effects in another state. If you can find any of these, it's transnational in nature, and that allows all of the member countries to use a convention to share and exchange information. What we have now are sexy terms that are being used, whether by diplomats, whether by criminal justice actors, whether by politicians. And the sexy terms are, in order to address this crime, we need a holistic approach. Think how many times people have heard that. The most recent one was, well, we need a whole of government approach to deal with the problem of terrorism and to deal with the problem of transnational organized crime. Lately, we heard not only do we need a whole of government approach, in the last UN Security Council Resolution 2178 on foreign terrorist fighters, they talk about having a whole of nations approach. So that is an understanding that somewhere across the borders, there's a lack of cooperation that the countries have had to deal with. The problems, and I'll lay out some of the challenges, and then we'll leave it for us to discuss, and of course, to get questions from you. The culture of information sharing. You have a culture that came out of the Cold War, where some agencies are not sharing with one another. So if they're not sharing with one another within their countries, how do they deal with information sharing across borders? It becomes even more complicated. We look at the incident that happened yesterday in Belgium. This happened in spite of the fact that there was an arrest that preceded that attack. And after the Paris attack, there was a joint investigation team, what they called a JIT, that was created by Belgium and France to be able to, quote unquote, connect the dots. The joint investigation team, of course, was limited to those two countries, even though when we looked at the Paris attacks, there were other countries involved within the European Union. Greece was involved, Austria was involved, Germany was involved, Spain to a certain degree was involved, but none of those made it to the joint investigation team because countries still limit the way they share information with one another. So this is a challenge. So when we meet to discuss, and we have these various fora to discuss how do we share information more effectively and how do we share information across borders, one of the things that's recommended is we have to destroy the various silos we have within our own governments. So you have on the one hand, let's focus on Europe. You have on the one hand a country that has information about its national traveling to a conflict zone to engage in certain criminal activity. That country is next to another country where they basically don't have any borders. But there is absolutely no harmonization of laws. So on the one hand, you can have a Danish citizen that travels to Syria to engage in certain activities. It's not a criminal offense. You can have a Belgian traveling to Syria, and it's a criminal offense, but then you can just drive across the border without a problem. So we have those issues, and whenever you have a crisis, and as it's often said, you never let a good crisis go to waste, the first thing they start doing is we need to harmonize our legislation to be able to have effective dual criminality if we need to capture an individual exploiting this open society that we've created. The fact of the matter is that no one does it in a proactive, strategic way. It's always in reaction. And it was the same in 2007 when terrorists were recruiting in one country of the European Union, and in other countries, recruitment was not a criminal offense. And so when they realized through intercepts and wiretaps that the criminals were saying, hey, listen, it's not a criminal offense for me to recruit in Spain, so get the brothers from Belgium to go to Spain to conduct a specific activity. And then, of course, the 27 members then, they added one more, decided of ministers of justice, let's meet and let's harmonize our laws so that it's a criminal offense in each European country to recruit for jihad. So we have those issues, we have those challenges, and we have, for example, in the transnational crime area, which I'll end with, a problem on the continent of ivory trafficking. In order to use the Transnational Organized Crime Convention, it must be a serious offense under the convention, which means that the sentence must be imprisonment of 4 years or more. But then you have certain countries within Africa that cannot benefit from that and are operating in silos. So Kenya will prosecute independently, Tanzania will prosecute independently. The ivory will be found in Togo on its way to a vessel that's going to Asia. Togo's not communicating with Tanzania. You have Ivory Coast, same problem. You have countries in the region. So these are the challenges that we have. And so in terms of the information sharing mechanisms that we need to have, it all starts with, I think, what the national governments are doing, in the sense that if you break down the silos within your governments, it allows you to share information with other governments. And if you really want to address the problem in the whole of nations approach, I think you're going to need to have serious commitment from the policymakers, serious commitment from the diplomats, serious commitment from the prosecutors and investigators working those cases to be able to share information across borders. One final point in terms of information sharing and who has a mandate. Mandate can be a virtue, but it can be a curse at the same time. So you have individuals who have a specific mandate to investigate a specific crime. At the same time, they see evidence of other crimes that are being committed, but are not collecting or preserving that information. So in one event involving charcoal smuggling, which we know is one of the primary methods of financing by al-Shabaab, you had naval vessels in the Indian Ocean that discovered all of the charcoal that was bound for the UAE. Because their mandate was maritime piracy, they did not stop that vessel and they allowed it to go forward. They did the same thing with weapons and the same thing with heroin trafficking that's coming to the continent. So, is the mandate a good thing? I think the proof is in the pudding. Thank you very much.
Thank you. Great. So I have a question for each, and then we'll open it up, and I'll go in the same order. So Philip, of course, there's a kind of chicken and egg story to be told, right? Do transnational and organized crimes create conditions where international crimes can be perpetrated, or do international, right? But I want to push you a little bit more on the exact link. Given that you're embedded within the International Criminal Court, really, is there any investigation of international crimes at the ICC in which those crimes could have ever been feasible without transnational and organized crimes? Charles, your remarks focused on transnational and organized crimes here in South Africa, and I want to push you a little bit more on the linkage issue then. Does it make sense, in your view, for South Africa to link transnational and organized crimes investigations or potential prosecutions with international crimes? And if it does, then how could you imagine that in a situation like South Africa where international crimes perhaps aren't being committed? Jemima, you mentioned terrorism, and I wondered what you thought about the recent remarks by Luis Moreno Ocampo that we need to, in a sense, criminalize terrorism. So his point is very similar to a lot of people's points, which is that we can't bomb terrorists. That creates greater disaffection, that fuels violence. And then he makes a small change, or a move of sorts, to say we need to stop treating terrorists as enemies, because that leads to violence and bombing, and instead treat terrorists as criminals. And I wondered what you thought of that. And then finally, Pierre, you spoke at length about cooperation and some of the challenges. If we think of the ivory trade that the LRA does, for example, this ivory obviously isn't going to wealthy Ugandans. This is going out of ports, be it in Mombasa or wherever it may be, often to areas like East Asia, Vietnam, Burma, and so on and so forth. How do you get the kind of cooperation and the understanding of a network that those who are maybe most responsible, to borrow a term from international crimes, could be held to account for transnational crimes, given the disparate distances and the porous borders that we see, given some of the remarks that you made? And with that, I'll also open it up to the floor for any questions. We'll take maybe 3 and then have another round. Do we have microphones? So we have 3 questions here. Perfect. So we'll go from the back forward. Is that okay? Yeah. Bill, please.
Thanks. The one question I have is, if you were trying to investigate and prosecute transnational crimes, can you realistically organize a regional court to be able to do this, or does it have to be done at the national level because of a lot of the issues that you raised today? And I also just wanted to make the point, and perhaps Philip will expand on it, that the difficulties in terms of adding new jurisdictions are amending the Rome Statute are enormous, and you did have in the adding the crime of aggression provisions on opting out, on completely turning the non-state party from a disadvantage to an advantage to governments that want to avoid the jurisdiction, would that inevitably pass on to any new jurisdictions that would be, or amended jurisdictions in the crimes? Thank you.
Thanks very much. And we have two questions up here. I'll catch you in the next round, and Femi, I'll get you in the next round. So, yeah. Either one.
Hannah Wolliver from the University of Cape Town. It actually follows on well from Bill's question to Philip. You mentioned the difficulties in amending the Rome Statute to include transnational crimes. I was wondering if you could comment on the possibility of instead judicial amendment through the use of Article 7.1k, the other inhumane acts of a similar character. Could we perhaps expand crimes against humanity jurisdiction judicially to include these transnational crimes in that way? Would that, do you think, be a viable option? Thank you.
Thanks. Fatia.
First of all, thank you to all the panelists. I think it was quite important and as well as interesting as far as I'm concerned. I'd like to maybe make a reflection and possibly a question in relation to one of the questions you raised, Jemima, which is basically looking at the root causes that lead to this sort of disease, really. And in doing that, I'd like to, link it to issues this morning in the Human Rights Panel, which is basically that we need to look at the root causes from a socioeconomic perspective of marginalization and disempowerment that leads, actually, to many people getting into illicit ways of generating income and resources. That's one. The second thing, would you agree that this happens also because there is a demand for ivory, or there is a demand for that, and therefore, to me, it brings back the question of actual double standards, in the sense that, you know, we know this happens, and yet you have people who demand those things. And I'll come back to the example of Somalia. I agree with you that the way that Al-Shabaab funds itself is through illicit sale of charcoal. But in many of the meetings I had with the ambassador for the UAE and so on, we are against that, we cooperate with the sanctions committee, and yet the charcoal goes to sort of the Emirates. Those are some of the issues I think we also need to look at. Thank you.
Thank you very much. Okay, so I'll give the panelists an opportunity to respond, maybe in reverse order. So, Pierre, do you want to start us off?
Sure. In response to your question, how do we deal with the issue in dealing with these networks? It goes back to again, a new sexy term that's bandied around quite a bit, and that is network of networks, right? And you need a network to defeat a network. And your network, your traditional networks, which were basically law enforcement, perhaps customs, perhaps immigration, has now expanded to other partners. It's expanded to Apple, which and other social media companies that have information that you need in order to identify crimes and that perhaps are not cooperating. It deals with organizations and companies, as I mentioned, like Apple, that have end-to-end encryption technology. To what extent should they share information with law enforcement, and do they share information and cooperate? You have, for example, as well, that, you know, civil society. You have the military, which is a non-traditional partner for many people that operate pretty much in a silo. You need all of these actors in order to really combat the problem in a truly transnational scale. And my recommendation certainly is to, you know, to start, I think, the dialogue at the national level. And then, of course, look at it from a regional perspective and ultimately deal with it at the global level. To the extent that we want to address a crime, for example, like ivory trafficking, I think we realize that, just to give you a basic paradigm, tusks that were recovered in Uganda made their way to the port of Mombasa. From Mombasa, they went to the UAE. From the UAE, they went to Colombo, Sri Lanka, bound for Thailand. okay, intercepted in Sri Lanka. No communication whatsoever between Sri Lanka and Kenya, or Sri Lanka and the UAE, and certainly no communication between Sri Lanka and Uganda, which was a source. That has to change, I think, if we really want to address the problem in a transnational way.
Yeah, thanks. Thanks very much.
Thank you very much. In terms of treating terrorists as enemies, no, not treating terrorists as enemies, but treating them as criminals, I think we've come a long way since 9/11. And since my own country was attacked, Kenya, in 98, yes? 98 years. And I think those days, we were actually fighting a war against terrorism. But with the developments around criminal responses to terrorism, and having observed the developments and the modus operandi of terrorism, I think it's necessary for us to continue to adopt, the criminal justice responses and treat them as criminals. One would say that a criminal is your enemy, but not necessarily, especially when you look at the recruitment processes. I mean, like in my own country, Kenya, I have read stories of neighbors and heard stories from people who said, my neighbor is my very good friend, and I didn't realize that he was actually involved in terrorism. That's not anyone's enemy, but that's a criminal. And I think what's most important to note here is the importance of upholding a human rights response when we are dealing with terrorism. Because when you're talking about an enemy, you want to smash your enemy and must go. If you're dealing with a criminal, well, you might want to, but you want to just keep him away. And I think the challenge that we have exposed ourselves to, and of course this goes back to a discussion that I had earlier today at tea time in looking at what has happened in Brussels yesterday, is that the way in which we are responding to terrorism is in a very sort of vigorous manner. We just want to smash them and kill them. And yesterday we also had about the response to, or what happened to Bin Laden, yeah. So instead of us, being so harsh to this person or to these people that we sort of branded as enemies, let us, let's think about them as criminals and then deal with them as you would deal with criminals. Because what we are observing is that if you don't deal with them as criminals, deal with them as enemies, kill them, then that of course now breeds more enmity. And as much as it breeds more enmity, we have seen what the repercussions have been. In terms of your comment about the root causes, it's a very difficult one because there have been all sorts of, causes that have been, highlighted as, being behind, for example, terrorism. Others have said that, it's issues around marginalization. Others have talked about poverty. But from my point of view, I think if we had our governance systems in place, whereby governance is a huge umbrella of all sorts of areas of development, areas of representation, I think we could actually be getting down to the roots. Because when you think of proper governance, it means that resources will be properly distributed. If it's education, all the areas or all the levels of communities will be provided with education, with resources. And obviously, I mean, we've got a lot of institutions and structures of governance in Africa and in our specific countries, but are they working? What do we need to make sure that they work? And I think the root causes are quite broad, and especially when you think of international crimes, it may not be an issue of poverty. It's an issue of greed. It's an issue of power. It's an issue of so many, factors. But at the end of the day, it's because somebody has that opportunity to either take advantage or has been able to raise, some resources that can enable him to perpetrate these crimes. That's why they take advantage of the system to be able to do that. Thank you.
Thank you. Please.
Thank
Charles.
you. I think your question, Mark, whether it would make sense for South Africa to link transnational organized crime with international crimes. Yes, partly yes, and partly no. First, partly no, in the sense that South Africa would have to ask itself whether it will make any real difference in terms of success in reducing or fighting this transnational organized crime. The fact that they suddenly became listed as international crimes. What are these crimes? commodity smuggling, for example, which is not directly an international crime, but is so intricately linked to international crimes. For example, smuggling of minerals from countries which are conflict affected, like the DRC, certain parts of it, which are quite closely connected to other, to international crimes directly. Illegal migration, human trafficking, certainly. It would, well, at a nominal level, these are also international crimes while also being transnational organized crime. But will it actually make a tangible difference in terms of the information that then becomes available to South Africa, and secondly, the effectiveness of the procedures, the processes to actually prosecute the perpetrators of these crimes? I don't think it will make much of a difference, because the same challenges that are being encountered now, while these crimes are transnational organized crime, would not disappear simply because they now became classified and treated as international crimes. Which also answers your question, Madam, on demand for commodities, demand, market-dependent crime. The challenge is international cooperation and getting different countries which are affected differently by the same crime to actually look at it in the same way, to share the same concern. Some countries benefit from some kinds of market-driven crimes. There's no doubt about that. That's why we continue to have tax havens, despite so many declarations at the G8, G20, and other summits. Certain countries do benefit, they continue to benefit. They will therefore pay lip service, but they won't do much. They will say, oh, we don't really know what's going on and who is involved. Can you give us the information? Or it's difficult and so on. So that challenge continues to exist. Is there a regional court to prosecute transnational organized crime? I don't know of any regional court that would be able to prosecute a transnational organized crime happening, for example, affecting any countries in Africa, which marks perhaps an unfortunate distinction between international crimes and transnational organized crime, because the regime of structures that's been established for international crimes hasn't been reflected or replicated for transnational organized crime.
Thank you.
Thank you. First of all, to your question, if I got you right, because it was a very sophisticated question, whether transnational organized crime actors have been part of ICL investigations or prosecutions, I would say they haven't yet, but they could, and they will at some point. Why? Because transnational organized crime is, as we've already established, sort of the ground layer for international crimes. It is fueling international crimes. Now the question is how to connect the dots. And if we don't find anything that in the international crime definitions, then what we have to look at is how does the connection work otherwise? And the connection can work through the form of liability, the mode of liability. And that would be in this case potentially aiding and abetting. Because what we have is we have a transnational economic actor that engages with an armed group in economic activities, buying their diamonds, selling them weapons, being full aware that with this economic transaction, the armed group will commit crimes, international crimes. This could amount to aiding and abetting because I direct a certain act towards the core perpetrator, knowing full well what the core perpetrator is going to do with it, even if it is for my own monetary gain and I really don't care about the crimes that are being committed. As long as I know about it, this could be a form of liability which is aiding and abetting, and this is how you get your transnational economic actor into an international core crime prosecution. Two challenges here though. Aiding and abetting in the ICC statute is linked to individuals as any other form of liability. What you have as your transnational economic actor is oftentimes a company or a sort of a group. Now, what you would have to first establish there is how to pierce the corporate veil, if I can steal that expression from the corporate law context. Because what you have to do is you have to dig yourself through evidence to the CEO, to the person that called the shot, that ordered this transaction to go forward, knowing individually full well what he or she was doing. This is the necessary requirement under the Rome Statute because we don't know corporate liability. We only know individual liability. Second challenge here, victims. If you have victims of these transnational crimes, they will not be part of the victim community at the Rome Statute level because the victim community at the Rome Statute level will only be those of the core international crimes. So the aider and abettor, while I could get the aider and abettor if I have the necessary evidence, the victims would remain indirect victims and therefore would not participate in the victim participation regime of the ICC, a factor to be considered. Regarding Bill's point as to the regional court for transnational crimes, I think that what one could arguably discuss is the jurisdiction that the African Court of Justice and Human Rights would have, because the jurisdiction in terms of criminal offenses that has been sort of drafted contains quite a long list of transnational crimes, which are arguably then part of the jurisdiction of that court. So one would have, if you want, a regional court with jurisdiction over these crimes. The question how operational that court in reality is a different one. But I think that in terms of the concept, if one looks at the possibilities of transnational corporate actors, in particular the money and power that these companies or that these actors have, I think at a certain point we get to the point that maybe at some point national special crimes units might have the problem that they're up against an incredibly strong and infiltrating network, and that maybe a regional solution would be something that one should look into. So I think it is definitely worthwhile entertaining that thought a little bit further. As regards Hannah's question for the expansion of Article 7.1k of the Rome Statute, which is crimes against humanity, and the subchef other inhumane acts, jurisprudence of the tribunals has made this sort of your entry gate for any other act that is not explicitly listed as a crime against humanity, as long as it rises up to the level of gravity of other listed crimes under crimes against humanity, murder, torture, deportation, and so on. Now, the problem here is that provision, by virtue of its definition, it says you have to inflict great suffering or serious injury to body or mental health. Now, that would arguably exclude a number of transnational crimes such as money laundering, smuggling, arms trafficking, drug trafficking, because there's no direct link to the harm of the victim. So you would not have a fully inclusive provision, and second, as I already said, you will always have the necessary chapeau element of crimes against humanity, which is your widespread and systematic attack. And that is a big problem in all these situations where you have simply transnational organized crime flourishing in action in a certain region, and you don't have necessarily this crime pattern of an international crime, so you would arguably be very limited in exercising your jurisdiction.
Okay, thank you. So I know we have a number of questions. I have them all written down. So let's just start with, so we got Femi, Mr. Spico, Chris Skeevers, who will introduce himself, the young woman here who will also introduce herself, and then Patrick Labuda, so 5.
Well, the area of corruption, at what stage, Philip, at what stage do you think corruption will qualify to be a crime against humanity? I mean, if a leader, president of a country stole $5 billion, as in the case of Abacha, money meant for roads stolen and people were dying on the roads, money meant to build hospitals diverted and people die in their thousands and millions, or the case of the Boko Haram, I know that on terrorism, the special prosecutor has already indicted the terrorists, as well as some of the soldiers who also engaged in mass killings of innocent civilians. Now, what of the military officers or the military authorities that diverted about $8 billion meant to procure arms and armament to fight terrorism? And in the process, about 25,000 people have been killed. Won't that qualify as a serious crime against humanity? The second one is just on information. Because of the fact that there is no way the ICC can possibly cope with demands from different parts of the world, don't you think we should encourage regional courts to deal with transnational crime? And already in West Africa, the ECOWAS court on its own has started a campaign to say, expand our jurisdiction to cover, criminal cases because of the type of cases that have been brought to that court. I mean, there was an incident where a guy in Benin Republic was promoting armed robbery around the region. We just simply sent armed robbers to different countries, and this guy was grabbed, brought to Nigeria for trial, and he went to the ECOWAS court, challenging the violation of his fundamental rights. We have had such cases. They find out one place. This is general. When a country or two plot a regime change to control oil in one country or the other, and troops are unleashed on that country to control the oil, and now millions of people are killed, others are displaced, won't that qualify as transnational crime?
Thank you. Pico?
This is for any of the panelists. Transnational organized crimes are not entirely new crimes in my own understanding. It's not like they've just been dropped from the skies yesterday. And I'm wondering whether you know of any jurisdiction that has succeeded in the fight against these crimes. That we can use as a best example, and if so, which jurisdiction and what makes that jurisdiction stand out? That's number one. Number two, instead of talking about the regional structure, why don't we, just in the same manner as we spoke yesterday about international core crimes, speak about capacitating national jurisdictions and borrow the Malabo Protocol model that creates divisions of investigative, prosecutorial, and judicial authorities that try both international crimes and transnational crime together.
Thank you. Actually, you can just hand the microphone right behind you.
Hi,
Please introduce yourself.
Yes, my name is Lauren Conn. I'm an attorney and I lecture in constitutional law and administrative law at the University of Cape Town. Thank you to all the panelists. My question is directed specifically to Pierre, if that's okay, regarding your comment about the need to destroy silos within government for information sharing, and the fact that you mentioned that a specific mandate can be a curse rather than a virtue. I understand the example you give in the transnational context, but I was wondering if you could clarify exactly what you mean by this within governments, the need to destroy silos. And the reason I'm wanting clarification, I'm thinking about this, is because is there not a counter-argument to be made that loose mandates and silo destruction on a national level can be a bad thing? I'm thinking in particular about what we've seen recently with the Hawks in South Africa, with their loose mandate. They're now investigating Pravin Gordhan's establishment of a so-called rogue spy unit within the SARS, which interestingly, as I understand it, did quite a lot of good when it comes to countering illicit trade, interestingly, in, for example, tobacco products and so forth. So, I mean, is it not arguably a bad thing to destroy so-called silos where we've got institutions whose independence, operational independence, needs to be protected? In a nutshell, that's my question. Thanks you.
Thanks very much. Thank you. Chris, just hand it back, yeah?
Hi, Chris Gievers from the University of KwaZulu-Natal. So I think it's a very important discussion. I just wanted to point out something very quickly, which is that critical international criminal lawyers have been talking about the political economy of atrocity for a very long time. The African court, for example, doesn't just have a combination of transnational international crimes, it also has a provision for corporate responsibility for those particular crimes. So the short answer to all your problems is to divest from the ICC and invest in the African court. Obviously, no one's going to do that, but let me say this. So it's a very important conversation, but 3 quick provocations. The first is that by saying this is transnational as a domestic question, not international, you reify that distinction. You keep saying that international crimes are political and domestic crimes are economic. Right? So it's the same pattern of criminality, it's the same network, but you're focusing on the international does the political and the domestic does the economic. That's problematic for reasons we know. The second provocation is that by limiting it to domestic jurisdictions, you're automatically going to focus on the source countries, not on the destination countries. So you're saying you're going to prosecute illicit flows, but you're going to focus on regional courts or African courts or complementarity, but you're not going to target the European jurisdictions where the stuff ends up. The third is that by ratifying that distinction of, and I'm nearly finished, by focusing on illicit transfers, you leave a whole host of legitimate transactions that themselves for centuries, in fact, if you take colonialism, but at least for the last 50 years, have generated international crimes. So you automatically legitimate the legitimate economy and you focus on the illicit. So we're talking about tusks, but not flows of money through legitimate channels into Swiss banks, for example. And that becomes problematic to the whole exercise.
Thanks for that comment. Patrick at the back. Laura? Yeah.
Yes, thank you. My question is, I think, primarily for Philip. I'm just wondering about this conceptual category, transnational crimes, because it seems to me like there are actually more differences than similarities between some of these crimes. I'm thinking of, for example, terrorism and ecocide. What do they really have in common? And I mention that not because I want to have a discussion about the theoretical concept of transnational crimes per se, but I'm just thinking it's a purely practical issue. You mentioned this idea of incorporating transnational crimes into the ICC's jurisdictional mandate. And I'm just wondering, does it make sense to incorporate transnational crimes per se, or is it a better choice to focus on discrete crimes, specific crimes such as maybe terrorism or human trafficking? And lastly, just what does the ICC think? Because you work there, so I'm just curious. What does the ICC think about this? Are they supportive of the idea of expanding the mandate or not? Thank you.
Great. And I've actually promised that I would ask a final question, which all of the panelists know, and they'll be very brief on it, which is simply the genie situation. So you have a genie, they grant you one wish to better link transnational and organized crimes with international crimes. You can make one change, one decision for any type of actor, a court, a government, an agency, whatever it is. What's the one thing you would want to see done immediately? All right, so we'll start, I think, maybe in the reverse order, so the original order as we did. So Philip, very briefly, please.
Okay, I'm trying to cover the ground that was fired in my direction. To start with the question of corruption as a crime against humanity, or trying to bring this into the area of an international crime, I think, again, my response would be very legalistic. I would be simply saying, let us look at the different crimes that we have under the statute and see whether we can subsume it. And if we can't, then we are not in the context of the ICC. If corruption has, as it usually would be, only a direct impact in that it would, for instance, lead to victimization further down the line, I would have a certain problem in using the term corruption as it is defined, by the way, in the UN talk as a transnational crime, to sort of infer from there the international crime. I think, as from a legal standpoint, I would have a problem there. Displacement of civilians to secure, for instance, oil wells or something like that. Displacement of civilians is arguably deportation or forcible transfer. That is an international crime. Now, if I can prove that the mens rea, i.e. the subjective element of those that order the securing of the perimeters, entailed pushing out the civilian population at all costs, I am looking at an international crime. Again, a very legalistic perspective that I would take on this. And then the question of should we encourage regional courts, and I think this is something that was an element of many questions. I think that what it comes down to, and this is very much true for the African court in its current status, and any other idea that would want to have, it always comes down to the money. How much money do you have at the ready in order to create such a court, in order to fund the court so that it can actually carry out its mandate, so that you have people working there that are sufficiently independent and that can really carry out high quality work, that you sort of have little to no dependency on particular national states that would be sort of the main responsible for funding. Funding is what makes or breaks a court, and we've seen this with previous experiences in terms of internationalized courts, and I see, for instance, Steve Rapp, who will be able to say a lot about this, I think. In terms of the question whether there are more differences than similarities between transnational and international crimes, I think, again, you have so many different facets of transnational crimes that one would really have to make a little bit of a distinction there in terms of what is already an element or could rise up to an international crime if the gravity level only rises up. And that is, for instance, these items of forcible transfer, where you are moving people. And that can be something that is only for monetary benefits without the necessary aim at hurting population, or it could also then become an international crime if it rises up to a certain level of gravity. Again, it is very much the legalistic definition that comes into this. Should we focus on discrete crimes if we were to think about elevating certain crimes into the area of international crimes? Yes, as a consequence of this, yes, because there are different qualities of transnational crimes, some of them, like transnational terrorism, being much more in the area of international criminal law than others. What does the ICC think? Money. We get limited funds from states parties. With these funds, we're able to carry out our core mandate, and that is going for the three crimes that we currently have operational in the statute. If you now overcharge the statute in terms of potential jurisdiction of the court, what you're actually doing is you're killing the court by giving it too much work without necessarily the court having the resources. So I would really say keep the ICC where it is and focus on everything that is the lower level. That brings me to the final point from Mark. If I could make a wish, I would say create regional organs or regional solutions. Start small, and this comes very much back to what Pierre has said repeatedly. If you start too big, you're running into trouble. Start small. Try for a regional solution that has a couple of states that share the same problem. Have them have a proper agreement on how to cooperate on things, on how to communicate on things, on how to come to a proper technical cooperation, how to deal with matters. That's where you're making progress, and I think that this is really the solution in particular for the most pressing problems in a regional context. Thank you.
My response to what the DPP raised, because transnational organized crime attacks or affects countries differently because of they are positioned differently. Kenya is not an island state, so you can't borrow lessons from Mauritius, for example. Mauritius probably has been more successful in tackling transnational organized crime, but they've also benefited from the fact that there are certain crimes that don't affect them in the same way as they would affect Kenya, for example. So I think it's better to invest time in looking at which countries have adopted the best possible elements of a mechanism to fight transnational organized crime, particularly those countries which are positioned similarly to Kenya, for example, because then you are more likely to come closer to the answer, because there's no way that you're going to get an ideal state which you can just sort of cut and paste from. Moving on straight to Mark's question, silver bullet, or it's not possible to get one, but I would say if it's in terms of priorities, I think get as much more information as is available out there on what is actually happening, map the networks of people that were involved, what forms of crime are we talking about, who is involved, where are they positioned, before you can even begin to talk about processes to combat their activities.
Thank you.
Thank you very much. Just to respond to the comment from the DPP of Kenya about whether instead of going the regional route in terms of responding to these crimes, shouldn't we, for example, establish specialized units at the national level to deal with the crimes? I think we actually should, because the regional arrangement is quite expensive, and with the discussions we've had now, it's almost not attainable in the very near future. We've got a few countries like Kenya and Uganda that has established specific units to respond to these crimes, and because the crimes are quite connected, then you have your prosecutors, you've got your investigators, and obviously the judiciary is at the national level, so they can speak to each other and perhaps deal with those crimes, together. And I think for me that is a good model that we need to adopt before even we think about getting to the national level. And in terms of the genie, there's quite a lot that I can say about that, but I think for me, what would do it is advancing governance. And I'll just leave you with one statement that if you want to walk fast, walk alone, but if you want to walk far, walk together. And that has to do with international cooperation for us to be able to respond to these crimes. Thank you.
Thank you. Yeah.
Sure. To respond briefly to the issue of whether to have a strict or a loose mandate, and to give you some clarification on that. The EU organization Frontex, for example, it has a strict mandate to engage in border control. But in the context of collecting information on border control, it collects information on a lot of other things, like terrorism. Frontex was collecting information on migrants coming in. Some of those migrants, as it's been established, have been terrorists that were infiltrating the European Union. And when that became clear that that was happening, the EU Council stepped in and expanded the mandate of Frontex to share information with another organization, Europol, on terrorists, and to be able to identify the links between the two. My concern, as I've expressed, is it's okay to have a strict mandate, but what happens while you're investigating within that strict mandate, you see evidence of other crime, what do you do with it? And I think those are the discussions that we're having with the International Criminal Court, as Interpol as an organization, and those are some of the problems that we're seeing in member countries. That the problem is not so much international cooperation problems, but rather national problems that manifest themselves in the international arena. So it's one thing, for example, for one country to say, we know that an individual is a terrorist or a criminal, and I've decided as a country not to place that person on a regional no-watch list. And the individual says, well, we wanted to do it, but within my domestic system, the prosecutor would not allow me to put that information that would benefit the collective. And so that's a silo within that country that people are dealing with. And I think many countries are beginning to realize that to deal with the international or regional cooperation even, you need to deal with the issues within the national jurisdiction, whatever works for you. Which brings me to the final point. If I were a genie or a king for a day, what I would do is I would strengthen existing structures and institutions. No need to create something new. At the end of the day, if you have strong national structures and jurisdictions, that's what will be sustainable. I don't think an international response or even a regional response is really that sustainable. What I've seen with crime in general is everything is local.
Great. Well, with that, please join me in thanking everyone here on the panel.